Chair recognizes Mr. Webster of Hanson.
Thank you, Mr. Speaker. Mr. Speaker, with respect to some of the comments that have made by members preceding me, there have been some very worthy arguments that have been put forth in support of this bill today. But let's call a spade a spade. And one of the arguments that has been made is that we should change the law, and the law should be changed so that the governor has to appoint a member of the person who has vacated the position's political party because the people of Massachusetts have elected someone from a specific political party. That is utter nonsense. The last time I checked, ladies and gentlemen, there were over 50% of the voters in this Commonwealth that were unenrolled voters. They're not electing someone to the United States Senate or any other office in the Commonwealth of Massachusetts because they're a Republican or a Democrat. They are electing them because they think that they are the right person for the job. So this talk about the voters selecting someone from a particular party is nothing more than nonsense. Secondly, with all due respect to my friend and colleague from Saugus, this constitutional issue is not a muddy issue. It could not be more clear. He talks about the 17th Amendment and he talks about the qualification clauses, which are two separate clauses in the United States Constitution. The 17th Amendment talks specifically to the appointment process and says that state legislatures may determine how to fill a vacancy in the United States Senate if such a vacancy occurs, which goes to the appointment or goes to the election. It says nothing about qualifications. It's silent on qualifications. We have a separate clause in the Constitution, Article 1, Section 3, that specifically defines what qualifications are for someone who serves in the United States Congress, either as a member of the House of Representatives or a member of the United States Senate. We have case law that my good friend from Sandwich mentioned previously. On 4 separate occasions, the United States Supreme Court has said that state legislatures and states, through votes of their citizens, cannot change the qualifications clause in the United States Constitution. The most recent case, a 1995 case, and he cited specifically the language, says that under no circumstances can states change the qualification clause in the United States Constitution, period. The only way it can be done is through an amendment to the US Constitution. I haven't heard anybody in this House today get up and rebut that argument. The only argument against it that I've heard today is from the lady, the gentle lady that preceded me several speakers ago in front of the mic, who raised the issue of standing and said that we are becoming overexcited about this issue when there isn't any standing to raise it. Well, the fact of the matter is that once this law is passed by this House and the Senate and becomes the law of the Massachusetts, either an unenrolled voter or a member of the Republican Party has standing to challenge this issue in the United States Supreme Court. I urge you to adopt this amendment.